we feel it's necessary to yak about bullshit in order to be comfortable?
I don't know. That's a good question.
Welcome back, everyone, and thank you for joining us here. I am your reluctant gringo. This is South of the Border, the channel where we cover pop culture and politics from south and below the Rio Grande. That's right, I live in Mexico. I'm an expat. I'm an American, but yet I love talking politics, and I love talking history, and I love talking pop culture. And today we got, I decided to come on because this morning I got up, and it seems like the Supreme Court's been extremely busy. Extremely busy. They issued over 5 rulings today. I know they got a huge docket they're trying to get through. We're still waiting on a lot of important cases, but they might have issued one of the most landmark cases for the culture war in the last 20 years that they've ever could. And this is a case that is, and let me get I'm going to get up their website, the Supreme Court's website. This is a case deemed United States versus Scarametti, all right? Now, what is exactly this case all about? Well, the state of Tennessee decided to pass a law basically saying that it is illegal, it is against the law in the state of Tennessee to issue puberty blockers or gender-affirming care to minors. All right, it is not a thing. If you're a minor and you identify as transgender or gender dysphoria or anything like that, regardless of your basis of sex, whether you're a male or a female, you cannot get this treatment. Now, if you're a minor and you need puberty blockers for another medical reason, which is stipulated within the law, whether it's you're entering puberty early or you have another congenital defect, something along those lines, something other than gender affirming or gender dysphoria care, yes, you can still get those puberty blockers. But as of right now, Tennessee decided to say, no, it's an ethical thing for us. It's a medical thing for us. And we are issuing this law and saying no to puberty blockers, no to transgenders. If you're a minor, you can't have it. It's done. Boom. Go to another state. Well, of course, 3 minors, transgender minors, their parents and a doctor sued, thinking that they could get equal protection underneath the 14th Amendment. Now, what is the 14th Amendment? The 14th Amendment is the amendment that basically states no matter what you are, who you are, where you are, you cannot be discriminated against within the law of a state. So they sued. And then they won in appellate court, and then they lost in the 6th appeal court, and then it went to the Supreme Court, and the Supreme Court said no. The Supreme Court has basically come down hard on transgender minor affirming care. This is a landmark case because it will affect every other state that decides to ban this type of activity. Now, of course, we have immediate reaction. Schumer, the leader of the Democrats, came out immediately and ripped the Supreme Court decision, calling it awful. So for Democrats and for progressives and liberals, this is a huge, huge loss because when we get into the opinion, oh my God, the opinion, it's one of the I would have been on earlier. It just took me forever to read through the opinion. It's one of the longest opinions I've ever read through from a court case, especially in recent memory. It's well over 80 pages long. It's got multiple dissents. It's got multiple opinions in affirming the decision of Tennessee. There is a lot of meat on this bone, but we're going to get to some of just the nitty gritties. I got some notes here. Want to be real, kind of be as basic as I can and give you the highlights of what this is. But I cannot state enough how badly of a loss this is for those who advocate for transgender surgery or transgender puberty blockers for minors. All right. It's a done deal in Tennessee, and other states that want to follow suit will look at that law and look how it's written and say, if we write the same thing, it'll uphold in court. Boom. And so now we're going to have a divide in the country between states that want to allow this to happen, states like California, things like that, and states that don't, states like Tennessee or Texas. I believe Texas is already working on this type of bill as it is. So again, it's a controversial issue. A lot of people fall on different sides of it. For me personally, I've always fallen on the side of, hey, a minor can't buy a beer. I don't think a minor can really choose to do this because it's such a permanent thing. That's just the way I am. That's the way I think. You may disagree with me. That's fine. You have your right to your opinion. But the Supreme Court agrees with me. Now, not only did Chief Justice Robert write the main opinion upholding the Tennessee law, the Judge Thomas, he wrote an opinion upholding the law, but I mean, it is blistering and is filled with other things that we just have against the LGBTQ community and other decisions made, which really says a lot about what might be going on in the minds of the justices. So with that, let's kind of get into it. But well, first of all, here we go. Senate Minority Leader Chuck Schumer slammed the U.S. Supreme Court's decision on Wednesday to uphold Tennessee's ban on transgender treatments for minors. Quote, he said, "This Supreme Court seems to have forgotten that one of their jobs is to protect individual rights and protect individuals from being discriminated against. It's an awful decision," Schumer told reporters on Capitol Hill. Well, unfortunately for Schumer, he lost the elections, and Trump can put in his conservative justices. It was a 6-3 decision. Here we go. All right, like I said, I made this thing a little bit bigger to be able to read, so that's why it says 118 pages. As we can see, here's where it begins. Again, I am not going to drag you through everything here, but there are some key arguments here. Basically, what the court decided, and Chief Justice wrote, is that the law in Tennessee does not discriminate on the basis of sex. Therefore, it does not apply under equal protection. Right? It doesn't say if you're male transgender, you can't have this, or if you're female transgender, it basically just says transgender. It's not transgender minors are not a protected class. And in essence, you could almost say transgender is, because of this ruling, not a protected class. Like if you're an African American or if you're a woman, those are protected classes, equal protection of the law. It even states in this syllabus, in this opinion, Chief Justice Roberts states it clearly, a protected class, and says these words. It's like women are the only people who can get pregnant. Literally throws in that little dig of science to the transgender community and advocacy. So you have a Supreme Court decision that literally states scientifically, morally, ethically, and by law, the only people who can get pregnant are women. I mean, we've heard that for years now. Men can get pregnant, men can get pregnant, men can get pregnant. Well, according to the Supreme Court, no, men can't get pregnant. Only women can get pregnant. Therefore, the whole idea that transgender is a protected class under the LGBTQ plus AA, whatever alphabet we're going with today, and I don't mean that to be insultive. I just don't know. It just changes all the time, and I'm tired of trying to remember it. But transgender is not a protected class. Therefore, you've got sanctuary cities like Worcester, Massachusetts, transgender sanctuary cities. Well, that's not a thing because you can't be a sanctuary city if the class isn't a protected class, but neither here nor there. So now, Chief Justice Roberts, very nice. He's the Chief Justice for a reason. He writes this opinion, basically says the law does not apply. This law is fine. The Tennessee law is fine. They can do what they want. Now, the part that I like to get to is, Justice Thomas is as conservative as they come. Let me tell you something. He was so pissed off. He was so fired up about this. He wrote his own concurring opinion regarding this. And he gets into it. Now we're going to get to, let's see here. One of the most important pieces of this, and because he really signals to the court that, and signals to the country that he would be okay with overturning some other protected so-called classes. And what do I mean by that? In 2020, there was a court case that was decided called Bostock versus Clayton County. This is basically the basis for LGBT members having certain protected statuses. Basically, you cannot discriminate in employment on the basis of trans or sexual orientation, as in far as how you identify, right? So it really kind of solidified that. And Justice Thomas totally disagrees with this. He says he really rails against that whole thing, even in this case with transgender. He's really seeing transgender as not a protected class, as something that we shouldn't even be looking at from a constitutional basis. He says the Constitution compels none of this, while the majority concludes that SB 1, that's the law Tennessee passed, does not discriminate based on sex. Even under Bostock's incorrect reasoning, I would make clear that the constitutional challenges courts need not engage Bostock at all. Basically, he's calling that ruling rubbish. He's basically calling out the ruling that protects certain employment discrimination for LGBTQ members. He's calling it rubbish. And he's basically signaling to the rest of the country and to the rest of the legislatures out there, hey, if you want to re-challenge this law, he might be on your side. So when I say there's a lot of meat on this bone, there's a lot of meat on this bone. It's not just, hey, we're going to uphold Tennessee's law. There's a lot of railing against the LGBT community in Thomas's decision. He states, and I wrote down some notes so I don't have to go through the whole thing with you. He states in his decision, states may make an ethical decision overriding effectiveness. Now, both Thomas and the Chief Justice, all the opinions basically look at Europe and say all these different scientific communities, all these different scientific studies have said puberty blockers don't work. Their effectiveness doesn't work. And that the harm they do is not known. The long-term harm they do is not known, and that we shouldn't be using it. So Europe, who led the whole sex change thing in the first place in the early 90s, has come about 180 and said, hold on, for minors and puberty blockers, let's stop it. The United Kingdom, Finland, all that, all the major players in that have all passed laws and said in their scientific community, stop doing this. The United States is basically the only Western country that has not said we're not going to stop doing this. We're going to keep moving forward. Why? I don't know, but there you go. So regardless of the effectiveness, Thomas states that even a state legislature can make a moral decision, as he calls it, an ethical decision, stating that the ethics of the state and the principles of the state and the values of the state and the people who live in that state and elect their officials can look at something and go, yeah, it might be an effective medical thing like transgender surgeries, but we just don't agree with it morally, so we can pass a law against it. That's a big deal. Like, that's a huge thing, right? For to have the Supreme Court or a justice of the Supreme Court say something like that and then put it in a decision that upholds certain laws. So he's basically saying ethics can overrule medical effectiveness. Now, that could have, you could think of that like assisted suicide or whatever, passing out clean needles to drug addicts. There's a ton of things like ethics versus effectiveness. So there's a ton of stuff that could affect. So he really used this chance, right? He also talked about consent. He basically said, can a minor ever truly give consent to permanent surgery? He basically came out and said it, and then Chief Justice Robert also concurred that minors, how can they give consent? They can't give consent to this type of stuff. That they won't ever be able to give consent to this type of stuff. That they're minors. They can't even drink a beer. They can't even vote, right? So why are we allowing them to do this? So the majority 6-3 decision upheld the belief that minors who identify with gender dysphoria or they identify as transgender and wanting to get sex change operations while they're 11, 12, 13, 14, whatever, even if the parents are saying, yeah, sure, no problem, no. All right, so it's too permanent and they're minors and they can't have it. All right. Now, the court also said that this, in Thomas's statement, this reserves the democratic process. Right? That regardless of ethics, regardless of the culture war going on, if a state legislature decides that something is unethical and they don't want it in their state, if the democratic process says, yes, we are going to pass this law and ban this type of thing, then it reserves it. So it's reserving that power for the state. So basically just totally blowing away the whole idea of transgender minors, puberty blockers. So if you want that kind of stuff, you're going to have to go to California. But it opens the door to federal action. Now that there's state action, it opens the door to federal action. So if the federal government, the legislature, Congress, Trump, all want to get together and say, we want to write a bill banning this type of stuff. Now, there's already executive orders out there by Trump that says, I'm banning this stuff in the government and whatnot. And that's all being challenging, right? That's getting challenged. This Supreme Court decision is basically giving ammunition to Donald Trump's executive orders to ban gender-affirming care, gender dysphoria care for minors throughout the country as an executive order. Again, there's no way around the Supreme Court. They've ruled this is a landmark case. You cannot put anything else around. This is a landmark case in the culture war of the 21st century. Now, Justice Barrett even wrote her own opinion. I mean, the justices really dug into this one, basically saying transgenders, they're not a protected class. They are not a protected class. Literally, specifically, you are not a protected class. You are not an African American who has to suffer institutional racism. You are not a woman who has to deal with getting a different level of pay just based off of your gender. All right. There's no test. There's no level of the law. And she even says it's a really high bar and you don't meet it. Transgender is not a protected class. That's a huge blow. And that is why the Democrats and the liberals, you see them in the news right now, coming out, including, like I said, Minority Leader Chuck Schumer, just absolutely blasting the Supreme Court on this decision. Again, 6-3 decision. You got the typical 3 liberal justices dissenting. We'll get into that in a little bit, just real quick. You got Sotomayor, who wrote most of the opinion. Ketanji Jackson Brown and Elena Kagan wrote a little bit, not much. They kind of just said, "Hey, we concur with this one." But yeah, it's amazing. This decision comes down. It really opens the door to a lot of different legislation. It opens the door to a lot of penalizing. Now, if you're in Tennessee and you're a doctor and you decide you're going to go against this law, not only can they take away your license, take away your practice, they can fine you thousands and thousands of dollars. At this point, you're going to see this type of law pop up in every conservative red state first, and then you're going to see the battle lines drawn within the blue states. And again, like I said, then you're going to see the federal government step in. And as long as Trump is on his culture war thing right now, and he's celebrating this case. He's absolutely celebrating this case. There's no way around it. They left no room to breathe. Transgender minors are not a protected class and should not be treated in the way in which the liberals and the progressives think they should be treated, regardless even of what their parents think or their parents say is okay. Just cannot happen. Done. Closed case. Yeah. You are not part of you are not a constitutionally protected class, folks. If you're out there and you're transgender and you've got your gender dysphoria, gender affirming needs, you're not a protected class. It does say at 18, do whatever you want. At 18, you can do whatever you want. But if the federal government says, "Hey, we're not going to pay for it, we're not going to cover it, we're not going to do this, we're not going to do that," or we're not going to protect you as a class, as far as employment discrimination, housing discrimination, any other type of discrimination, they've got an open door to try that. That's really, there's a lot said in this case. Again, over 80 pages of written judicial opinion. Amazing. Now, just real quick, Sotomayor basically came out and their argument is people are going to hurt themselves. People are going to be psychologically and physically harmed, and we should be protecting these minors because they're going to have mental issues. Now, there's been a 40-fold increase since the early 2000s of minors who identify as transgender. I don't know if that, take that for what it is. But in her opinion, that if we don't allow people or minors to have puberty blockers, if we don't allow minors to go through this permanent life-altering surgery, that they're just going to end up harming themselves. Well, in that case, I would say that we need to get some mental health issues ironed out, get them help, get them therapy right now until they're 18, make a decision, right? But allowing them to do this, we're not going to let them do it. But Sotomayor is basically saying you're opening the door for all these transgender minors to do self-harm to themselves, or self-delete and all that stuff. So, or just be embarrassed, right? She likens it to, she said something in her opinion, if you're a boy and you wear a dress to school, you're going to get ridiculed. Well, it's the same thing mentally for trans. No one's telling them what to wear. No one's telling them, they can wear whatever they want. Right? If you're a biological male and you feel like a female and you want to wear a dress, wear a dress. No one's saying you can't do that. She's likening it to jobs that only males might do, which I'm not really sure what those are. Besides, again, I didn't think I thought men and women could do the same jobs, but she even likens it to there are jobs out there that women can't do that men can, and they'll be ridiculed and all. I'm like, so there really wasn't much weight behind her arguments, basically just saying that we want people to feel good. And that's just not how the law works, folks. It's not like how the law works. But anyways, So again, you have the opinions of the court. They did issue 5 different opinions, but the big one is the United States versus Scarametti. All the other opinions they issued today are basically things that really don't affect you unless you're in that industry. But yes, we have the Democrats. They are pissed off. So they are pissed off. It starts with Schumer. And you're going to hear about this from everybody from AOC on down. But the Supreme Court has ruled. Done. End of story. Let me know what you think. Do you agree? Do you disagree with this opinion? With that, I am. Boom. There I am. Woohoo! All right. With that, I just wanted to get on real quick and just comment on that before we start going to war, because that'll be tonight's show when we go on war. But with that, so I hope everybody's having a good day. Again, let me know what you think in the comment section below. If you like this video, make sure you like and subscribe. And that's right. Everything from I'm still your reluctant gringo from south of the border. Salud, a huevo. We out of here. Boom.
you